In this short video, let's discuss one of the important topic that is going to actually affect the time required for grant of your patent, the fees that you are going to pay for the government fees you are going to pay for the patent, and not only that, but also the ownership of the patent, as well as when we consider the international patent application, at that time also the kind of fees that you pay to PCT application, even that is going to affect with this decision. Now, this is where we seen the applicant, or let's say the inventor, gets confusion most of the time, and rightly so, because there are 3-4 factors to be considered here. We are talking about choosing the applicant for your patent application. Now, first thing first, let's discuss who is inventor and who is applicant, because we need to choose inventor and applicant when we are filing a patent application. Choose as in we need to report the information about inventors and applicant for the invention to the patent office. Now, inventors are very straightforward. They are always human beings. Companies or other things cannot be inventor. So these are human names. The people who have created the invention, researched on it, or maybe help in creation of it. It could be manufacturer, or let's say a team which help you build the AI module for your invention. That can be added as a co-inventor, totally your discretion. And maybe a mentor who guided you for your research can be added as a co-inventor. So inventor is very straightforward, human being who helped create the invention. It could be Indian, or it could be even foreign people or team member also. Now, once you are clear with the inventors, the second most important decision for which this video is created is choosing the applicant. Now, why it is important? First thing first, applicant decides the ownership. I mean, whoever you choose as applicant actually considered as owner or co-owner of the patent. So they will have the legal rights, assuming that there are more than one applicant. So everybody involved in the decision of whether to sell the patent application, or patent, not application, maybe granted patent, whether to license it or whether to proceed with certain deal or not. So they will have the say in whatever decisions you take about the patent. We are talking about applicant, not the inventors. So choosing an applicant makes a long-term impact, particularly because a lot of things has to be considered. Let's talk about the faster grant of patent in India now. So this is possible by expedited examination, that is Form 18A, to be filed for the request for expedited examination. Now, there are different ways to do it, but long story short, instead of taking 3-4 years or more time for the grant of patent, or let's say examination of your application, the grant of patent can happen well within 1 year, sometimes even 6-7 months from the filing. So the expedited examination helps us reduce the time required for grant of patent in a significant way. So who is eligible for filing Form 18A? Now let's consider that, so that you can decide which option to take if you are planning to go for expedited examination. And it should be, I mean, 99% of the patents that we file actually opt for this. For natural reasons, we are just paying few thousand rupees more. Let's say if you are an individual, instead of 4,000, which is regular fees for examination, you are paying 8,000 rupees to the government fees for expedited examination, but you are cutting down more than 2-3 years of time. So your patent would be examined very quickly, 3-4 months of time, 2-3 months of time. We would respond to it, and it should be granted well within 1 year. So that's all about Form 18A. Now let's consider the categories which are allowed to file Form 18A, so that you can select the applicant properly if you belong to these categories. The first is startup recognized by DPIIT or DIPP. So it is a recognized startup in India that will have the startup certificate. Those companies can go for Form 18A and expedite the examination. If you have MSME certificate for your legal entity, then you still can go ahead for the Form 18A. Then if you are a female applicant, or you have female as a co-applicant. Co-applicant means you are the inventor, you are filing a patent application, but you are adding a female from your family or colleague or whoever it could be, your spouse, your cousin, whoever you trust with the ownership of the patent, and her name can be added as a co-applicant. PAN card would be required as an identity proof while filing the application. Soft copy of PAN card would do, and then that patent application can be expedited filing Form 18A. Then if you are a government institute, or you have filed an international patent application and you have chosen ISA as India or IPEA as India. So ISA means International Search Authority, IPEA is International Preliminary Examination Authority. Little complicated to understand here, but for now the context is, if you are international entity, if you have filed international patent application and choosing ISA or IPA as India, you still can go for expedited examination. Now, for the normal context, the conflict is very clear. Like, you're filing patent in India, you want to get patent granted as soon as possible. Naturally, you can maybe have a MSME certificate or a startup certificate, and as a legal entity, you file patent application and get it granted within 1 year. So there is no brainer. Now, when we consider the PCT application, that is International Patent Application, PCT is a provision. I mean, there is a separate video if you want to refer to PCT applications. Then the scenario is a little tricky, because if you are filing as a legal entity, let's assume MSME or startup certificate, you will get the patent granted very soon in India. However, if you are filing as a PCT application, any legal entity will have the fees in the range of 1.2 lakh, 1.3 lakh, sometimes even 1.5 lakh, based on number of pages and the currency values. While we are paying the fees to, you would get the what we can say, the demand letter about the fees to be paid. This is government fees. 1.2 to 1.5, 1.3 lakh is government fees. You're filing for PCT application, Patent Cooperation Treaty application. So may it be startup, may it be MSME, may it be any form of legal entity, you are bound to pay that fees. But if you are filing a PCT application as an individual or group of individual, more than one individual as applicant, it could be male, female, then the reduction in fees is 90%. So you can imagine, instead of 1.3 to 1.5 lakh rupees as a government fees for PCT application, you end up paying 18 to 19,000, sometimes even 15, 16,000 rupees as a government fees. So here is the dilemma, or not even dilemma, we can say the facts to consider while selecting the patent applicant. So if you are an individual, it is straightforward. Have somebody as a co-applicant as a female. It could be your family member, again, colleague, or maybe your relatives. You can trust and have her name as a co-applicant. You can expedite it in India, get the faster grant, just paying by 4,000 extra rupees, as I mentioned. And when you're thinking about going to global stage, or let's say international application, there also, being an individual, you two or maybe more than two people are applicants, you end up paying less fees for official fees for the PCT application, which is like 90% reduction in the fees. Now, if you're a legal entity and then you are trying to get the benefit of MSME or startup certificate, you still can do that. But while at the stage of PCT application, you need to consider this expense as more than 1 lakh rupees as a government fees for PCT application. Now, for most of the legal entities, fortunately, this is not a big of a problem, because it is still affordable. I mean, something not you can't afford. However, the decision point is very clearly can be made from the starting point itself. Why an individual would want to file a patent on a company's name? Well, there are 2-3 scenarios here. First thing first, you are raising funding for the company, and naturally, when funding people look at your company, they would want all the IPR or intellectual property, including patents, to be in the name of company, because they are funding it, not in the name of director or owner. So that's one of the requirement. Second, you are utilizing it for licensing, or so it is better to have in the company's name. Third, you are using it as an asset, maybe raising some equity or raising some what we can say loan out of your IPR and capacity. So even that condition also would be better handled by having it on the company's name. And there are lots of scenarios where having the IP on company's name is preferred. So I hope this has helped you, coming into terms with how to choose an applicant for your patent application. Feel free to contact us for any confusion or any what we can say sub questions or something that we couldn't answer in this particular video, we are always happy to have a one-on-one discussion and help you out with your decision. Thank you so much for your time. Take care. Bye bye.